Question 1. In a high-stakes environment where multiple challenges impact a corporation's decision-making, the board of directors is deliberating major acquisition. Dissenting director claims that the acquisition will disproportionately benefit the majority shareholders at the expense of the minority shareholders. In light of fiduciary duty principles, which of the following best describes the director's legal obligations? A. The board of directors must approve the acquisition as long as majority vote is obtained, regardless of its impact on minority shareholders. B. The board of directors must act in the best interest of the corporation as whole, ensuring that no shareholder group is unfairly disadvantaged. C. The board of directors may prioritize the interests of majority shareholders as they hold controlling votes. D. The board of directors must seek shareholder approval for any acquisition, even if not legally required, to avoid potential liability. Answer B. The board of directors must act in the best interest of the corporation as a whole, ensuring that no shareholder group is unfairly disadvantaged. Explanation. Under corporate fiduciary duty principles, particularly the duty of loyalty and duty of care, directors must make decisions that benefit the corporation as a whole rather than favoring specific shareholder groups. The business judgment rule allows directors to make business decisions with presumption of good faith, but if there is a conflict of interest or unfair treatment of minority shareholders, the decision may be challenged in court. A. Incorrect. While majority vote often suffices, directors cannot act to the detriment of minority shareholders, as this may constitute breach of fiduciary duty. C. Incorrect. Directors cannot prioritize majority shareholders. Their duty is to the corporation as whole. Dodge v. Ford Motor Company. D. Incorrect. Shareholder approval is not always required, though certain transactions may be subject to second state corporate provisions. Question 2. During a major transformation where existing methods of employee compensation are being revised, a company converts from a general partnership to a limited liability company (LLC). Several partners argue that their previous compensation structure should remain unchanged despite the new legal structure. Under U.S. Business Association laws, which of the following statements is most accurate? A. The new LLC must honor all previous compensation agreements of partners without modification. B. The LLC has no obligation to maintain the previous compensation structure unless explicitly stated in the LLC rating agreement. C. Former partners have the right to demand that their prior compensation arrangements be incorporated into a LLC's new structure. D. All compensation agreements made in the partnership automatically carry over to the new LLC under default corporate conversion laws. Answer B. The LLC has no obligation to maintain the previous compensation structure unless explicitly stated in the LLC rating agreement. Explanation. When a general partnership converts to an LLC, it becomes a legally distinct entity with its own governance and compensation framework. LLC members' rights and obligations are governed primarily by the LLC rating agreement, which must explicitly incorporate any prior partnership agreements for them to remain enforceable. A. Incorrect. Unlike corporation, an LLC does not have an automatic duty to retain previous financial agreements unless legally bound. C. Incorrect. While partners can negotiate, there is no automatic legal right to demand previous terms. D. Incorrect. Conversion statutes do not automatically transfer contractual obligations without explicit agreement. Question 3. While analyzing the root causes of sequential problems in a large firm's contract negotiations, newly appointed officer discovers that significant number of contracts include arbitration clauses that may not be enforceable under U.S. law. Under business contract law principles, which of the following scenarios would likely render an arbitration clause unenforceable? A. The arbitration clause requires arbitration in foreign country with no legal representation allowed. B. The arbitration clause includes provision allowing one party to unilaterally modify the terms of arbitration. C. The arbitration clause states that only one party has the right to select the arbitrator. D. All of the above. Answer. D. All of the above. Explanation. Arbitration clauses are generally enforceable under the Federal Arbitration Act, but courts may strike them down if they are unconscionable, unfairly one-sided, or violate public policy. The following scenarios would make an arbitration clause unenforceable. A. Foreign arbitration without legal representation. U.S. Courts may refuse to enforce arbitration clauses requiring proceedings in unreasonable jurisdictions or denying a party legal representation as they violate due process. Mitsubishi Motors v. Solar Chrysler Plymouth, 1985. B. Unilateral modification. Clauses allowing one party to unilaterally change arbitration terms are considered unfair and violate contract principles of mutuality and fairness. Hoot, America Inc. B. Phillips, 1999. C. Sole arbitrator selection by one party. Courts have ruled that clauses granting one party exclusive control over arbitrator selection lack neutrality and violate basic fairness standards. Graham v. Sisseltail Inc. 1981. Question 4. In a situation where formal requirements conflict with practical business considerations, a corporation is faced with a dilemma regarding compliance with corporate governance rules. Zeiss Corp, a publicly traded company, recently acquired a startup in a highly regulated industry. Due to the nature of the industry, the board of directors of Zeiss Corp must make immediate strategic decisions without waiting for the formal shareholder approval process outlined in the corporate bylaws. However, some shareholders argue that such decisions require a formal vote before execution. The board justifies its actions by citing the business judgment rule and the necessity for swift decision-making. Additionally, Zeiss Corp is incorporated in a jurisdiction that adheres to Delaware corporate law, which provides significant deference to directors' decision-making in the absence of fraud or self-dealing. Following is the most accurate legal analysis of the situation. A. The board of directors is justified in making immediate decisions under the business judgment rule as long as they act in good faith and in the best interests of the corporation. B. The shareholders' claim is valid because corporate bylaws take precedence over the board's discretion and failing to hold vote breaches fiduciary duties. C. The board's decision is unlawful unless the corporate charter explicitly allows for emergency decision-making with shareholder approval. D. Delaware corporate law does not recognize the business judgment rule in cases where shareholder rights are implicated. Answer. A. The board of directors is justified in making immediate decisions under the business judgment rule as long as they act in good faith and in the best interests of the corporation. Explanation. Business judgment rule. The business judgment rule protects directors from liability if they make decisions in good faith, with due care and in the corporation's best interests. In Delaware corporate law, unless there is fraud, self-dealing, or gross negligence, defer to directors' decisions. Shareholder rights versus board discretion. While shareholders have voting rights on fundamental matters, e.g. mergers, corporate governance allows directors to make urgent strategic decisions. Bylaws can impose additional requirements, but they generally do not override the board's statutory authority in emergencies. Why B, C, and D are incorrect. B overstates the authority of bylaws over directors' discretion. C misinterprets the role of the corporate charter. While it can grant specific powers, the board retains significant default authority. D incorrectly states Delaware law, which strongly supports the business judgment rule. Question 5. During a major transformation where existing methods are challenged, a partnership is transitioning into an LSC. A group of business partners operating a general partnership GP decide to convert their entity into a limited liability company LLC to gain liability protection. However, one partner, John, objects, claiming that the transition will dissolve the existing partnership and cause him to lose his contributions and voting rights. The remaining partners argue that the transformation does not constitute dissolution, but rather a continuation of the business under a different legal structure. The partnership agreement is silent on entity conversion, and state law is unclear on whether unanimous consent is required for such a transition. What is the most legally sound approach in this scenario? A. The partnership must dissolve first before forming an LLC, and John's capital contributions must be distributed before new entity is formed. B. The conversion can proceed without John's consent because state law provides default rules allowing majority decision-making in structural changes. C. The transition can be executed if statutory merger or conversion process is followed, provided the partners comply with applicable entity statutes. D. John has valid claim to prevent the transition since fundamental change requires unanimous consent in the absence of explicit provisions in the partnership agreement. Answer. C. The transition can be executed if the statutory merger or conversion process is followed, provided the partners comply with applicable business entity statutes. Explanation. Entity conversion and state laws. Many states allow partnerships to convert into LLCs via statutory conversion or merger processes without requiring dissolution. This allows continuity of business and assets while shifting liability structures. Wayne Consent may not be required. While partnership agreements sometimes require unanimous consent for fundamental changes, default statutory rules in many jurisdictions allow a majority vote to approve a conversion unless the agreement specifies otherwise. Why A, B, and D are incorrect. A, incorrect because statutory conversion avoids dissolution. B, assumes state law allows majority decision-making in all cases, which varies jurisdiction. D, overstates the necessity of unanimous consent. Default rules may permit conversion with less than unanimous approval. Question 6. In a multi-location scenario where consistency requirements affect operations, a multinational corporation (MNC) faces a regulatory conflict in multiple jurisdictions. A U.S. based limited liability company (LLC) operates in multiple states and internationally. Some of its European subsidiaries must comply with General Data Protection Regulation (EDR) rules, which require strict data protection measures. However, certain U.S. states where the LLC operates, such as Texas, have less stringent data privacy laws. The board of the DLLC is unsure whether it should GDPR-compliant policies across all locations or apply different standards based on each jurisdiction. Which legal approach should the LLC prioritize to mitigate risk? A. The DDR-compliant policies across all locations to ensure compliance with the strictest standard and reduce liability exposure. B. Follow only the data protection laws applicable to each jurisdiction, as applying GDPR beyond its required scope could increase compliance costs. C. Use a hybrid model that applies GDPR in European operations but follows local laws in U.S. states, minimizing unnecessary compliance burdens. D. Exempt U.S. operations for DDR, as the regulation only applies to entities with an establishment in the EU. Answer: 8. The DDR-compliant policies across all locations to ensure compliance with the strictest standard and reduce liability exposure. Explanation: extraterritorial reach to GDPR. DDR applies not only to businesses established in the EU but also to those outside the EU that process EU residents' data. If the LLC collects, stores, or processes any personal data from EU individuals, it must comply with GDPR. Legal and business risks of non-compliance. GDPR penalties are substantial, up to €20 million or 4% of global revenue, whichever is higher. Many multinational companies implement DDR standards universally to streamline compliance and reduce the risk of regulatory action. Why B, C, and D are incorrect. B, incorrect because localized compliance can create operational inefficiencies. C, while hybrid model may work in theory, inconsistent policies can lead to internal conflicts, regulatory confusion. D, misunderstanding DDPR's reach. It applies even to companies outside the EU that process EU residents' data. Question 7. When unforeseen circumstances challenge traditional business structures, a corporation may need to reassess its governance framework. TechCorp, a Delaware-incorporated company, has recently expanded through multiple joint ventures, creating a complex web of corporate relationships. The board of directors is now considering adopting a dual-class stock structure to retain voting control while issuing additional shares to attract investment. However, some institutional investors argue that the move would reduce shareholder influence and breach fiduciary duties. What is the most legally sound approach for TechCorp to implement this restructuring? A. The board can unilaterally approve the dual-class structure as long as it acts in good faith and in the corporation's best interests. B. The company must obtain shareholder approval before implementing the structure since it fundamentally alters voting rights. C. Delaware corporate law prohibits dual-class stock structures, so the plan is legally impermissible. D. The move is valid only if the board discloses its intent and the risks involved in compliance with federal securities laws. Question 8. In an era where innovation drives corporate growth, legal compliance remains a cornerstone of sustainable expansion. A venture capital-backed startup, GreenGen LLC, has developed proprietary renewable energy technology. The company is seeking additional funding but wants to avoid stringent securities regulations by offering convertible debt instead of equity. However, some investors argue that the convertible notes should be classified as securities under federal law. What legal standard will determine whether these instruments are securities under U.S. law? A. The Howey test, which defines an investment contract as a security if it involves an investment of money in a common enterprise with profits expected from the efforts of others. B. The corporate charter's definition of securities, as state laws govern classification. C. The SEC regulation D exemption, which automatically classifies all convertible instruments as non-securities. D. Convertible notes are never securities as long as they incur repayment obligation. Answer: D. The move is valid only if the board discloses its intent and the risks involved, ensuring compliance with federal securities laws. Explanation: Delaware corporate law permits dual-class stock structures, but transparency is critical to prevent claims of unfair dilution or entrenchment. SEC regulations require proper disclosures when implementing voting restrictions. Why A, B, and C are incorrect. A. The board has discretion, must disclose changes. B. While shareholder approval may be advisable, it's not always required. C. Delaware allows dual-class structures. Answer: A. The Howey test, which defines an investment contract as a security if it involves an investment of money in a common enterprise with profits expected from the efforts of others. Explanation: Convertible notes may be classified as securities if they meet the Howey test criteria. Why B, C, and D are incorrect. B. State laws don't determine federal securities classification. C. Regulation D provides exemptions but defines securities. D. Convertible notes can be securities depending on structure. Question 9. As regulatory landscapes evolve, businesses must adapt to remain compliant with corporate and securities laws. A large private equity firm is planning to take a publicly traded company private through a leveraged buyout (LBO). Minority shareholders object to arguing that the transaction is coercive and undervalues their shares. The firm argues that the board approved the deal in good faith and within its discretion. Which legal stat applies in determining whether the buyout is fair to minority shareholders? A. The business judgment rule, which protects the board's decision if made in good faith. B. The entire fairness standard, which requires fair dealing and fair price in conflicted transactions. C. The market efficiency test, which evaluates whether the company's stock price reflects its intrinsic value. D. The shareholder protection doctrine, which requires unanimous shareholder approval for buyouts. Answer: B. The entire fairness standard, which requires fair dealing and fair price in conflicted transactions. Explanation: LBOS can trigger fiduciary concerns, particularly if controlling shareholders or insiders benefit disproportionately. Why A, C, and D are incorrect. A. The business judgment rule may not apply in conflicted transactions. C. Market efficiency is relevant but not determinative in fairness analysis. D. Unanimous isn't required in standard LBOS. Question 10. During a major transformation where existing methods must adapt to new corporate structures, conflicts can rise in governance decisions. Zeiss Corp is undergoing a merger with a smaller but highly specialized technology firm. The board of directors of the acquiring company is concerned about retaining key talent from the target firm, while also ensuring compliance with fiduciary duties to shareholders. A dispute has emerged regarding allocation of golden parachutes to certain executives in the acquired company. Which of the following legal principles should primarily guide the board's decision? A. The business judgment rule, which protects directors from liability if they act in good faith and in the company's best interests. B. The Revlon standard, which mandates that directors maximize shareholder value in certain sale transactions. C. The duty of loyalty, which prohibits self-dealing transactions unless fully disclosed and approved. D. The entire fairness standard, which applies when controlling shareholders influence the outcome. Answer: B. The Revlon standard, which mandates that directors maximize shareholder value in certain sale transactions. Explanation: In a merger, directors must prioritize shareholder value, especially when a sale is inevitable. Y, C, and D are incorrect. A. The business judgment rule may not apply when a company is for sale. C. Duty of loyalty applies to self-dealing, not necessarily M. Decisions. D. Entire fairness applies in conflicts involving controlling shareholders. Question 11. We're in a high-stakes environment where multiple challenges arise simultaneously. Regulatory compliance becomes a key issue for corporate decision-making. A financial institution is expanding internationally, triggering compliance concerns under both U.S. and foreign laws. The board of directors is debating whether to adopt a universal corporate compliance policy or customized compliance strategies based on each jurisdiction's regulations. Which factor should be most critical in determining the company's approach? A. The extraterritorial reach of U.S. securities and anti-corruption laws, such as the Foreign Corrupt Practices Act (FCPA). B. The company's preference for uniform policies to simplify operations. C. The ability to negotiate exemptions from foreign regulators. D. The avoidance of compliance costs, as penalties can be absorbed if violations occur. Answer A. The extraterritorial reach of U.S. securities and anti-corruption laws, such as the Foreign Corrupt Practices Act (FCPA). Explanation: U.S. laws like the FCPA can apply to international operations, making compliance a top priority, while B, C, and D are incorrect. B. Uniformity is desirable but secondary to legal compliance. C. Negotiating exemptions is rare for major U.S. laws. D. Absorbing penalties is not a sound corporate strategy. Question 12. When improving a process that shows unexpected results, businesses must assess the impact of contractual obligations on their operations. A manufacturing company recently outsourced a key production process but is now facing delays and quality control issues due to inconsistencies in the supplier's performance. The original contract includes liquidated damages clause for non-performance. Which legal principle is most relevant? Determining the enforceability of this clause. A. The clause is enforceable as long as it was negotiated in good faith and does not constitute penalty. B. The supplier can avoid enforcement if the delays were unforeseen. C. Courts will automatically void liquidated damages clauses if they impose financial burdens on one party. D. The company must renegotiate the contract instead of enforcing the clause. Answer A. The clause is enforceable as long as it was negotiated in good faith and does not constitute a penalty. Explanation: liquidated damages clauses are generally enforceable if they reflect a reasonable estimate of potential losses and are not punitive. Why B, C, and D are incorrect. B. Foreseeability does not necessarily void contract terms. C. Courts assess reasonableness, not automatic voiding. D. Renegotiate, optional, not required. Question 13. While analyzing the root causes of sequential problems in corporate liability, directors must assess their legal duties. A pharmaceutical company has been sued for failing to disclose negative clinical trial results related to a new drug. Shareholders allege that the board breached its duty of oversight by not implementing adequate reporting systems. Which legal standard applies in evaluating the board's liability? A. The Caremark Doctrine, which requires boards to implement and monitor internal compliance controls. B. The Entire Fairness Standard, which applies to self-dealing transactions. C. The Business Judgment Rule, which shields directors from liability unless gross negligence is proven. D. The Fraud on the Market Theory, which applies only to individual stock trades. Answer A. The Caremark Doctrine, which requires boards to implement and monitor internal compliance controls. Explanation: boards have a duty to establish reporting mechanisms to detect and prevent compliance failures. Why B, C, and D are incorrect. B. Entire fairness is for conflicts of interest. C. Business judgment rule does not apply to oversight failures. D. Fraud on the market applies to securities fraud, not board liability. Question 14. During an emergency response where multiple areas are impacted, corporate governance must balance rapid decision-making with fiduciary responsibilities. A publicly traded company is dealing with a major cybersecurity breach that compromised sensitive customer data. The board of directors must disclose the breach to regulators, shareholders, and customers, but they are concerned about potential stock price impacts. Under securities laws, when must the company disclose the breach? Only after the company has completed a full internal investigation and quantified damages. B. As soon as the breach is discovered, regardless of financial impact. C. When the breach is deemed material to investors under the Securities Exchange Act of 1934. D. Only if the breach results in significant financial losses. Answer C. When the breach is deemed material to investors under the Securities Exchange Act of 1934. Explanation: SEC regulations require disclosure of material events that would influence investor decisions. Why A, B, and D are incorrect. A. Waiting for full investigation could be too late. B. Immediate disclosure is not always required if immaterial. D. Financial loss is one factor but not the sole determinant. Question 15. When implementing new protocols in a shared environment, businesses must consider potential liabilities of joint ventures. Two large healthcare providers form a joint venture to develop a telemedicine platform. However, one partner is accused of violating HIPAA data privacy laws, and regulators are investigating whether both partners are liable. Which of the following best describes the liability exposure of the joint Partners. A. Both partners are automatically liable for each other's violations, regardless of involvement. B. A liability depends on whether the violating partner was acting within the scope of the joint venture's authority. C. Only the violating partner is liable unless the other party had explicit knowledge of the violation. D. Joint ventures always provide liability protection to individual partners. Answer. B. Liability depends on whether the violating partner was acting within the scope of the joint venture's authority. Explanation. If the partner's actions were within the venture's scope, joint liability may arise. Y8, C, and D are incorrect. A. Joint liability is not automatic. C. Explicit knowledge is not always required for liability. D. Joint ventures do not inherently protect partners from liability. Question 16. While examining inconsistencies across various units, corporations must evaluate the legal implications of differential treatment of stakeholders. A multinational corporation is accused of treating minority shareholders unfairly in one of its subsidiaries by providing preferential treatment to majority shareholders. Which standard will courts most likely apply in evaluating this claim? A. The business judgment rule, which presumes decisions are made in good faith. B. The entire fairness standard, requiring proof that transactions were fair in process and price. C. The market efficiency doctrine, which applies to stock pricing models. D. The corporate veil doctrine, which determines when shareholders can be held personally liable. Answer. B. The entire fairness standard, requiring proof that transactions were fair in process and price. Explanation. The entire fairness standard applies when controlling shareholders benefit at the expense of minority shareholders. A, C, and D are incorrect. A. Business judgment rule does not apply to self-dealing. C. Market efficiency doctrine relates to stock markets, not corporate fairness. D. Corporate veil doctrine concerns liability, not shareholder treatment. Question 17. In a case where multiple parties have different objectives, the board must balance competing fiduciary duties. A corporation is negotiating a hostile takeover, and the board is considering a poison pill defense to prevent the acquisition. Shareholders are divided. Some support the takeover while others oppose it. Which duty does the board primarily owe in this situation? A. Duty to maximize shareholder value at all costs. B. Duty to reject hostile takeovers to protect company independence. C. Duty to act in the best interests of the corporation and all shareholders. D. Duty to favor majority shareholders over minority shareholders. Answer. C. A duty to act in the best interests of the corporation and all shareholders. Explanation. Boards must balance long-term corporate interests with shareholder value. A, B, and D are incorrect. A. Maximizing value is key, but not at all costs. B. Rejecting all hostile takeovers is not required. D. Boards cannot favor majority shareholders unfairly. Question 18. When scaling up operations that experience significant complexity, corporate boards must ensure compliance across jurisdictions. A U.S. company is expanding operations into the European Union, where stricter general data protection regulation (GDPR) rules apply. The company must determine how to handle cross-border data transfers without violating compliance rules. Which strategy is most legally sound? A. Transferring data freely between US and EU offices as long as internal policies exist. B. Using standard contractual clause SECS approved by EU regulators to ensure lawful data transfer. C. Ignore GDPR as US laws supersede EU regulations for American companies. D. Relying on implicit customer consent without explicit agreements. Answer. B. Using standard contractual clause SECS approved by EU regulators to ensure lawful data transfer. Explanation. SECS are an approved legal mechanism for transferring personal data. DDR. A, C, and D are incorrect. A. Internal policies alone are insufficient. C. US laws do not over a DDR. D. Explicit agreements are typically required. Question 19. While updating traditional approaches where interconnections exist between different business units, corporate governance must address conflicts of interest. A CEO of a publicly traded company serves simultaneously on the board of a competing firm. Shareholders claim this creates a conflict of interest. Which of the following best describes the board's responsibility in addressing this issue? A. The board must require the EO to resign from one of the companies. B. The board must determine whether the CEO's roles create an actual conflict of interest. C. The EO is allowed to serve on both boards without restriction. D. The board has no obligation to intervene unless shareholders formally object. Answer B. The board must determine whether the CEO's roles create an actual conflict of interest. Explanation. Boards must assess whether dual roles compromise fiduciary duties. Why A, C, and D are incorrect. A. Resignation is not automatically required. C. Dual roles can be problematic if conflicts exist. D. Boards must proactively oversee conflicts, not wait for shareholder objections. Question 20. In a situation where formal requirements conflict with practical realities, corporate governance must balance compliance with efficiency. A technology startup is in the process of going public through an IPO, initial public offering. However, the company's board realizes that some founders have significant control through dual-class shares, raising concerns about minority shareholder rights. Which regulatory principle applies in this case? A. The Securities Exchange Act requires that all shares must have equal voting power in public company. B. The board must seek shareholder approval before issuing dual-class shares. C. Dual-class structures are allowed but must be disclosed to investors in IPO filings. D. Founders must give up majority voting power after the IPO to ensure fairness. Answer C. Dual-class structures are allowed but must be disclosed to investors in IPO filings. Explanation. Dual-class shares are commonly used by founders to retain control but must be clearly disclosed under SEC rules. Why A, B, and D are incorrect. A. U.S. law does not require equal voting power. B. Boards can issue dual-class shares without shareholder approval before going public. D. Founders are not required to give up control post-IPO. Question 21. During the introduction of new methods where coordination across teams is essential, conflicts may arise between business units and legal compliance. A multinational corporation is adopting AI-driven decision-making in its hiring process. However, there is a risk that algorithmic bias could lead to discriminatory hiring practices, violating employment laws. What is the company's best legal course of action? A. Rely on AI decisions and assume compliance unless discrimination lawsuit is filed. B. Ensure that AI model is audited for bias and complies with anti-discrimination laws. C. Only use AI for advisory purposes without impacting hiring decisions. D. Implement AI fully but allow employees to appeal its decisions manually. Answer B. Ensure that AI model is audited for bias and complies with anti-discrimination laws. Explanation. AI hiring tools must comply with laws like Title Roman of the Civil Rights Act to prevent bias in employment decisions. Why A, C, and D are incorrect. A. Legal compliance cannot be assumed. C. AI can be used, but safeguards are required. D. Manual appeal is useful but does not prevent bias at decision-making state. Question 22. In a multi-location scenario where consistency requirements must be maintained, compliance with different jurisdictional laws is key. A U.S. based company operates in California, Texas, and New York. However, California has stricter privacy law (CCPA) than the other states. Which approach best ensures compliance? A. Apply California's stricter privacy standards to all U.S. locations to maintain uniformity. B. Create state-specific compliance policies tailored to local laws. C. Follow only federal privacy laws, as they override state laws. D. Rely on customers to opt in to different privacy policies based on their location. Answer A. Apply California's stricter privacy standards to all U.S. locations to maintain uniformity. Explanation. Applying California's CPA across all states simplifies compliance and reduces risk. Why B, C, and D are incorrect. B. State-specific policies are complex to manage. C. Federal laws do not override state privacy laws in all cases. D. Relying on customer opt-in creates legal uncertainty. Question 23. While managing a hybrid approach where timing issues create complexity, businesses must navigate regulatory requirements. A global bank operates both brick-and-mortar branches and online financial services. However, digital transactions are subject to different regulations than in-person banking services. What is the best approach to regulatory compliance? A. Apply brick-and-mortar banking laws to all operations for consistency. B. Develop separate compliance policies for online and in-person banking. C. Focus on local regulations for physical branches but ignore online banking laws. D. Use online banking platforms from countries with weaker regulations to avoid restrictions. Answer B. Develop separate compliance policies for online and in-person banking. Explanation. Online banking is regulated differently than traditional banking. E.g., fintech laws, cybersecurity laws. Y, A, C, and D are incorrect. A. Traditional banking laws do not fully cover digital transactions. C. Ignoring online banking laws is legally risky. D. Using offshore platforms to avoid regulations is not legally defensible. Question 24. In an environment where different components must interact smoothly, legal frameworks must account for interoperability. A pharmaceutical company acquires a biotech startup to integrate new drug development into its pipeline. However, the biotech's intellectual property IP is based on third-party patents. How should the company ensure legal protection in this merger? A. Assume all biotech patents transfer automatically after the acquisition. B. Conduct IP due diligence to verify licensing agreements before finalizing the merger. C. Proceed with integration and deal with licensing issues later if they arise. D. Require the biotech firm to cancel all third-party patents before merging. Answer: B. Conduct IP due diligence to verify licensing agreements before finalizing the merger. Explanation: merging companies must ensure all IP is properly transferred and licensed to avoid legal disputes. Why A, C, and D are incorrect. AIP does not automatically transfer. C. Dealing with issues later creates liability. D. Cancelling patents is unnecessary and impractical. Question 25. While analyzing the root causes of sequential problems in compliance, organizations must ensure transparency in reporting. A publicly traded company discovers internal fraud by an executive. The company is concerned about its SEC reporting obligations and potential investor lawsuits. What is the company's best course of action? A. Handle the issue internally to prevent public panic. B. Immediately report the fraud to regulators and shareholders if it is material. C. Only disclose the fraud after legal proceedings are complete. D. Wait for external auditors to raise the issue before addressing it. Answer: B. Immediately report the fraud to regulators and shareholders if it is material. Explanation: SEC regulations require companies to disclose material events that impact investors. Why A, C, and D are incorrect. A. Internal handling may violate transparency rules. C. Delaying disclosure could be seen as fraud. D. Waiting for auditors could lead to legal penalties. Question 26. When scaling up operations that experience significant regulatory differences, companies must align business expansion with legal frameworks. A U.S.-based financial services company is expanding into Europe, where GDPR, General Data Protection Regulation, imposes stricter data privacy laws than U.S. regulations. Which strategy ensures compliance with EDR while maintaining U.S. operations? A. Apply U.S. data privacy laws globally as they are less restrictive. B. Establish two separate compliance policies, one for the US and then one for Europe. C. Require European customers who opt out of DDR protections when using US-based services. D. Store all customer data in the US to avoid European regulations. Answer: B. Establish two separate compliance policies, one for the US and one for Europe. Explanation: GDPR applies to any company handling European customer data, regardless of location. Why A, C, and D are incorrect. A. US laws do not over DDR. DDR protections cannot be waived by customers. D. Storing data outside Europe does not exempt companies a free. Question 27. During a comprehensive review of a process that needs improvement, ensuring shareholder rights is critical in corporate restructuring. A public company is undergoing a merger, but some minority shareholders believe the deal undervalues their shares. What legal option do minority shareholders have to contest the merger? A. File a shareholder derivative lawsuit against the company's board. B. Seek appraisal rights to receive fair market value for their shares. C. Refuse to sell their shares and force the company to cancel the merger. D. Demand equal voting power with majority shareholders. Answer: B. Seek appraisal rights to receive fair market value for their shares. Explanation: appraisal rights allow shareholders to challenge merger valuations and receive a fair payout. Why A, C, and D are incorrect. A. Derivative lawsuits apply to wrongdoing by directors, not valuation disputes. C. Individual shareholders cannot block a legally approved merger. D. Minority shareholders do not automatically receive equal voting power. Question 28. While investigating a complicated issue between different corporate entities, legal liabilities must be clearly defined. A parent company owns a subsidiary that faces lawsuits for environmental violations. The plaintiffs want to hold the parent company liable. Under what legal doctrine can the parent company be held responsible? A. Piercing the corporate veil if the parent company directly controls the subsidiary's actions. B. Automatic liability for all actions of wholly owned subsidiary. C. The business judgment rule protects the parent company from liability. D. Subsidiaries' legal structure prevents lawsuits against the parent company. Answer A. Piercing the corporate veil if the parent company directly controls the subsidiary's actions. Explanation: courts may pierce the corporate veil if subsidiary lacks independence and is merely an alter ego of the parent company. Y, B, C, and D are incorrect. B. Ownership alone does not create liability. C. The business judgment rule protects decisions, not legal separations. D. Subsidiary structure does not guarantee immunity for the parent company. Question 29. In a scenario where efficiency decreases across multiple divisions, restructuring must comply with corporate law, or a corporation with multiple divisions is spinning off one of its business units into a new independent company. However, some employees and investors worry about legal and financial implications. Which factor must be considered to ensure a legally compliant spin-off? A. Shareholders must approve the spin-off in a proxy vote under SEC rules. B. The parent company retains liability for the spun-off business indefinitely. C. Employees automatically transfer to the new company without consent. D. The new company must assume all debts of the parent company. Answer A. Shareholders must approve the spin-off in a proxy vote under SEC rules. Explanation: SEC rules require shareholder approval if a spin-off substantially changes corporate structure. Y, B, C, and D are incorrect. B. The parent company's liability depends on legal agreements. C. Employees must agree to transfer in some cases. D. The new company only assumes debts if specified in the spin-off agreement. Question 30. When implementing new protocols in a shared environment, compliance challenges arise between different regulatory standards. A US healthcare company is launching an international telemedicine platform. However, medical licensing laws differ across countries. What approach ensures compliance? A. Only follow US telemedicine laws as the company is based in the US. B. Require all doctors on the platform to hold multiple international licenses. C. Ensure country-specific compliance by verifying local licensing rules. D. Allow doctors to practice freely online without regard to local laws. Answer C. Ensure country-specific compliance by verifying local licensing rules. Explanation: medical licensing is jurisdictional and doctors must meet local regulations before practicing in a specific country. Y, A, B, and D are incorrect. A. US laws do not override foreign licensing requirements. B. Not all countries require multiple licenses, but each nation has its own rules. D. Ignoring local laws violates legal and ethical standards.